Do you care about your child, its economic and emotional well-being? Should children born in marriage put on equal footing with illegitimate ones when calculating child support, respectively distributing the surplus funds? Watch this video on child support as well as distribution of the excess cash. Find out why, according to the Federal Supreme Court of Switzerland, financial equality between children of formally married and non-married parents does not seem to make sense. This according to a decision of July 19, 2023. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If this video appeals to you, please like and share it. The case is based on the following facts. A and C were not wedded to each other. They never lived together. A son was born on March 18, 2016. He was under joint parental custody and maternal care. The parents could not agree on child support contributions. The court said this as the son, assisted by a lawyer, sued the father. The father appealed, requesting lower maintenance contributions. The only issue before the Swiss Federal Tribunal was how the large and small heads were to be counted when distributing the surplus funds in the case of unmarried parents. Child support is to be calculated according to the two-tier concrete method with surplus distribution. Surplus funds are in principle allotted according to large and small heads. In individual cases, this may be deviated from at the judicial discretion, which must be justified. According to the doctrine, parents are considered as large head and children as small head. A double surplus share is allocated to a large head. In the case of unmarried parents, it is a debatable point whether the parent providing care without paying child support should be regarded as large head when distributing the surplus funds. The Federal Supreme Court has commented on this for the first time. The child is entitled to childcare maintenance or maintenance for caretakership, in German Betreuungsunterhalt, regardless of the parent's civil status, as coupled or married, if he or she is personally cared for by one parent. This means that children born in wedlock and children born out of wedlock are generally treated equally in terms of care. However, there is no question of financial equality irrespective of civil status. The legislator provides the following concerning child support. The child maintenance contribution should correspond to the child's needs as well as to the parent's circumstances and resources, factoring in the child's assets and income. However, the legislator leaves it up to the courts to decide how to work out child support. According to the Federal Supreme Court, the living costs must be ascertained based on the concrete circumstances of the individual case. The child support due is a dynamic variable. It can vary considerably. The child's maintenance claim depends on the parent's means, on the resources to be distributed, on the number of households to be financed, on further half-siblings entitled to child support, and furthermore, on whether also spousal maintenance or post-marital spouse support has to be paid. In the case of unmarried parents, it must be ensured that the child's surplus share does not cross-subsidize the parent providing care, because the latter has no claim to maintenance of his or her own against the other parent. Any childcare maintenance, economically intended for him or her, is limited to the minimum subsistence level under family law, not containing a surplus share. The surplus share should only enable the child to participate in the living situation of the parent liable to pay child support. The unmarried parent providing care shall not additionally be co-financed. However, according to Article 289, paragraph of the Swiss Civil Code, the child support contribution is paid to the child's legal representative or the person with whom the child resides. In principle, there is shared money and no Dutch treat. From the excess cash, the need for leisure activities, hobbies, and vacations is financed. In the case of favorable circumstances, the age and the increased need should be considered. However, even in the case of above average circumstances, the need should not extend immeasurably. It should be stemmed appropriately for educational reasons. To sum up, when distributing the surplus funds, consider whether the parents are married to each other or not. In the case of married or divorced parents, a total account with mutual maintenance obligation is made. In the case of parents who are unwed and one parent has sole custody, only one parent is liable to support the child. Therefore, the calculation takes place only between the parent and the child, and the surplus is distributed only between them. The other parent cares for the child. In the case, the father intended to allot only 20% instead of 33% of the surplus to the son. He argued that the mother should have been virtually counted as a large head. However, the Federal Supreme Court dismissed his appeal, reasoning that virtually no large head should be used for the parent in charge of the son because the mother has no own maintenance claim. Thus, she was not entitled to participate in the surplus. There is no way to virtually credit the mother with a share of the surplus, because this would violate the child's due maintenance claim. So please note down your personal situation. Are you married or not? How old are your children? What are their living expenses? Please note also down how these are composed of. Do you desire a just, amicable, and modern separation or regulation that you negotiate on your own terms? You need a preparation and someone on your side for support. Please contact me for a joint conversation and also follow me on social media to be up to date and not to miss any news.